Hello, and welcome back to Hagan's New Jersey PIP Tips, where we bring you monthly segments on New Jersey auto insurance personal injury protection, otherwise known as PIP. We had a crazy busy January with unwinding from the holidays, taking down the decorations, and a ton of arbitrations, partly probably because so many were put off in December. So we didn't have last month's video, so welcome back to 2025. It's amazing. We just had the Super Bowl, crazy game. Congratulations to the Philadelphia Eagles and their fans. Today we're going to be talking about examination under oaths, or EUOs, and recorded statements. Quick update on the GEICO Class Action suit. Our featured provider of the month, Levinson Axelrod. And then, of course, we'll pick the new winner, which will be the first winner in 2025. So let's start the New Year's off right and get right to it. So a recent trend I'm starting to see again, which the insurance companies regularly go through, is where they're taking what's called an examination under oath, or EUO, or at least a recorded statement of the insureds, of the patient who were involved in a car accident. If you're treating a patient, or if you're counsel for a person injured in a motor vehicle accident, you need to talk to them. And maybe at the initial visit, initial consultation, let them know if they get contacted by their insurance carrier for either a recorded statement or an examination under oath, to let you know, so you're aware and you can discuss with the patient the things that may come up during that recording, during that examination. Often they go on these fishing expeditions, asking questions, what kind of services were performed, who performed them. So make sure the patient understands the services that you are providing to them. I can remember back in the day, many, probably 20 years ago, they asked a 9-year-old in an examination under oath whether they had a modification of orthosis. Now, all that meant was, did they have a mouthpiece that they had that he had to take out and the doctor had to modify it. Of course, the 9-year-old didn't know what modification of orthosis was, so he said no. And they relied on that statement to then say, well, the doctor never performed it. Now, if they would have asked the follow-up question, did you have a mouth appliance? Did you have to take it out and present it to the doctor? Did the doctor do something to it? Maybe they would have got the clear answer. But they weren't necessarily concerned about the clear answer. They were concerned about getting a reason to deny. Often we see, what was the name of the doctor who was treating you? Did anybody else help or assist? Particularly lately, I've been seeing it with chiropractors who have licensed chiropractic assistants, where they're saying, oh, well, the girl or the guy put the pads on it for electric stimulation. And of course, they're then denying the whole claim, not even just the electric stimulation. They're denying the whole claim and saying, that it was performed by somebody who's not licensed because it wasn't done by the doctor. Now, if they're educated, or if they reached out to the provider and found out that they had a licensed chiropractic assistant and that they can put the electrodes, the electric stimulation on, and actually even, I think, turn it on, that might be a different situation, but they don't want to get to the bottom line, the truth, and they may not even tell the doctor that's the reason they're denying it. They may just say it's based on a statement or our investigation, we're denying the claim. So talk to your patients, talk to your clients, and say, let them know if they get a notice of these EUOs or recorded statements, to let you know, and so you can discuss the case with them in terms of what their complaints have been, what their treatment is, who's been treating them, etc. I've seen as far as back in the day and occasionally recently where they're showing pictures of people and saying, do you know this person? Trying to see which doctor treated or if a doctor didn't treat. So sometimes it's because they're truly trying to figure out if there's proper coverage, whether they were a resident relative because it's not their policy, and they have reasons to take them, but many times it's being done to go on a fishing expedition. Also, by knowing that you're going to have it, you can also, if you choose, have an attorney participate on your behalf. This way they can ask those follow-up questions. If I was on that EUO back in the day with that child, I would have asked them the follow-up question. Well, did you have that appliance? Did you have to take it out and give it to the doctor? Did the doctor use a little tool to modify it or scrape it or cut it? And it would have been crystal clear. But no, they do it sometimes, what I say, in the dark without anybody knowing, and then the defense comes out at the end. So just a little different thing that I haven't really talked about before is EUO's recorded statement. If you have questions about it, obviously you can always reach out to me. We're always here for your questions and answers. You can reach me at either Sean@SeanHaganLaw.com, or you can call me at 732-722-2911. And we're always happy to answer these questions or any of your New Jersey PIP questions. Next, I briefly want to give you an update on the GEICO Class Action suit. The motion for summary judgment is still sitting out there pending a decision by the court. We haven't heard any update. It's been some time now, many, many months, and nothing new. Related to all this, I will let those know who are chiropractors in New Jersey. This month, February 20th, the ANJC, Association of New Jersey Chiropractors, has invited me to present a seminar on PIP and its advanced training, where we're going to cover the details of pre-certification, pre-service appeals, post-service appeals, healthcare primary. It's going to be the 20th of February. We're hosting it at Forest Gate Country Club in Monroe, New Jersey, so it's kind of conveniently in the middle of the state. It includes a free breakfast. It's free for members of ANJC. We're almost down to the deadline for signing up. It gets you, I believe, 2 credits of continuing education, and again, at no cost to you. So I look forward to those who will be attending to see you on February 20th. Next, I want to talk about our featured provider of the month, Levinson Axelrod. Congratulations, Levinson Axelrod, for being selected. Rather than me talk about this wonderful law firm that specializes in personal injury that I worked closely with over the last 10, 15 years, here's a short video from them to explain their services and commitment to excellent relations.
The firm philosophy at Levinson Axelrod is working as a team to ensure the maximum recovery for our clients. No 2 cases are alike. And that's why it's such a resource to be at a big firm like Levinson Axelrod, because it means that we have the collective knowledge of decades and decades of experience amongst the various attorneys.
A lot of what we do is helping them through the process. God forbid they lost a loved one, or they've been in a terrible accident, or they can't get back to work. They don't know where to turn. They don't know what's going to happen, what they need to do, and really helping them through that process is a big part of what we do.
At Levinson Axelrod, one of the benefits our clients have is that we are local. We have 10 offices throughout the state because our clients don't want to go 2-3 towns over. They want to go to their lawyer who's local. And that's how our firm philosophy is: your neighbors, your lawyers. We are there for you.
My clients don't just know me, they know my assistants, they know my associates, because every client is a firm client. Of course, we give them individualized attention when we're representing them as the attorney on their case, but you come into the office and it's just more of a family atmosphere. We're all pulling for all our clients as a team to make sure that the clients know that we're doing this for them and that we're here for them, whatever they need.
We're looking for justice, which is to obtain monetary damages to equate for what has been lost by that person in terms of pain, suffering, disability, loss of enjoyment of life, how it affects their lives. You look for somebody who's going to be your advocate, fight for you. You have to prepare yourself. That means doing the research, and that helps get better results.
Here at Levinson Axelrod, we always prepare every case as if it's going to go to trial. By having a track record of going to trial on a regular basis and being successful when you do so, they know you're going to be ready to try the case. And as a result, when it comes to negotiating cases, you're always going to do better. I can't tell you how many times I've been in court and heard judges say to my adversaries, you have to pay them more. They're Levinson Axelrod. You know they're going to try the case and you know they're good at it. As a result, that benefits our clients.
You're doing this for the worker and you're doing this for the victim. Whether it's a negligence case or a workman's comp, you're doing it to help people that need help, that can't navigate it or the system on their own. You got to work every angle. The most important thing is sort of get them to the right doctor, get paid while you're out of work, and then you can get a settlement.
When you're in the business that we're in and you see these people firsthand, you see people whose lives have been messed up, you really want to help them. And this applies to even minor injuries because injuries affect people. We're going to do what we can to make it right.
When you've been injured in an accident, it's so important that you have the correct legal representation. One of the mantras that we've always used is it really does matter what attorney you choose. And in this case, if you choose Levinson Axelrod, you're getting a team of seasoned litigators who have experience handling these cases, have gotten maximum recoveries for our clients in the past, and will continue to do so into the future.
Well, as you can see, they're top-notch for personal injury, Levinson Axelrod, and if you have cases in their area, by all means, reach out to them. You can reach out to me, and I can get you in touch with them also. So congratulations. As you know, each month we select a winner for Provider of the Month. All you have to do is communicate with my office, and we put you in the drawing. You can do phone calls, emails, in-person visits, sending your demands for arbitration to be filed at no cost to you. Anytime we have an interaction with you, we put you in for a drawing and you can be selected. If you're not selected this month, there's always next month, so keep those communications going. So let's pick a winner today. And the winner is, come on, one ticket, Pereira Chiropractic. Congratulations. We'll be in touch with you shortly for next month's video. Well, we hope you enjoyed this video and found it useful. Please like, share, and subscribe to the links below. As always, we're never too busy for your kind New Jersey PIP and personal injury referrals. Thank you, and God bless.